Do we have sound now? I'm hoping that we do. Let me turn this off. I do not have all my normal gear. Doing the best we can. Yes, Steven says yes. Now there's sound. Okay, fantastic. Very good. Hello, everybody. I am here in Florida at my dad's house. We always have little gremlins with the equipment, and today's a completely different system. New Wi-Fi, new microphone, camera on the road, but it appears to be working. Baruch Hashem. I was playing the intro music. I just forgot to switch over to this other mic. I blame no one but me. I'm not blaming the equipment. I should have been out here just dry running this thing earlier, but I've just arrived. I've just arrived today, and I'm trying to get this whole thing to work. So hold on a second. Let me just double check that we are on YouTube also. I think we are. Very good. Let me know on YouTube. Marjorie, Ella, and Bestis Muchness. Shalom from Minneapolis. What's your name? But let me know that you can hear me on YouTube, please. Okay, so Yehudit's in the house. From South Carolina, Sharon in New Jersey, Stephen in New Hampshire, Shandor in the Bronx, Mickey, good evening, Sal. I'm sorry I was impatient yesterday. I lost someone very close. I'm so sorry, Mickey. May the neshama have an aliyah. Joe from the Inland Empire, Bill in Mid-Missouri, Lucy in Minnesota, Sharon, there was no sound, but I think we've got it. Melissa in Great Neck, Bell in Texas, Guy in Ohio. Oh my God. Sharon, my husband and I lost a friend today too. Wow. And I lost a friend last Sunday. I've talked about that. Here in Florida, I actually was able to go visit my mom's grave today. That was very powerful for me. So may all these sweet neshamas have a great aliyah, great elevation in the world of souls. Also welcoming Miriam in Arkansas, Bella in Florida, Sandra in Georgia. Welcome. Chaim in Florida as well. Great. So, okay. Sound is excellent. Did I just see that? Yes, the sound is excellent. Baruch Hashem. Okay. So let's do our daf. I prepared it today on the plane. It was a, a red eye. So hopefully I'm as ready as I think I am. We shall see. Okay, our daf today is daf Lamed Tes, page 39, here in Tractate Bava Metzia, the 22nd volume of the Talmud. We are picking this up near the bottom of page 38b and continuing our discussion of Mishnah number 4. Just double checking. Mishnah number 4 here in chapter 3. Okay, and we're talking a little bit about what happens if somebody's unable to tend to their property. Are we going to allow a relative to step in and manage their property for them? We've been talking about lost objects, right? Returning lost objects. That's what chapter 2 was all about. And now we're saying that somebody who steps in and is acting as, first we were talking about yesterday, the Baili, right? So somebody who's entrusted to care for someone's produce, and the sages say, no, you can't touch the produce unless the produce begins to rot very quickly. And then to prevent the total loss, you can be assured that the owner would want that, and you can step in. Except that there's a problem, because if the owner, and they didn't have cell phones, they weren't in close communication, and the owner might have been away and had other produce that he was mentally designating at the produce in the Bailey's care, he would separate the tithe from that and thereby make the produce that is in some other location tithed produce, which would be available for eating. But if the Bailey, who was entrusted to care for this produce, was thinking that, well, it starts rotting very quickly, let's sell it, then the guy who's trying to separate tithe from this produce entrusted to the care of the Bailey thinks he's making a tithing, thinks he's separating teruma. The first 2% is teruma for the priest. The next 10% is called the tithe, and that's given to the Levium. But if the produce no longer exists, it's no longer in the care of the bailee, then there's nothing to separate. There's no tithe. There's no produce to act as the tithe. And then they would be consuming or selling untithed produce unknowingly, and they would come to commit a transgression. So that's what we were talking about yesterday. Now we're also talking about how could somebody else come to be entrusted with managing somebody else's property. So another example is somebody, and we can imagine this, was taken captive, and they left a farm field. Right? So the field maybe was ready to be harvested, or maybe it needed to be planted. Is the captive going to come home? Is the captive still alive? We don't know. Who is going to step in and manage that property for them? Well, it should be the court, but who's the court going to appoint? What if the person is not really missing? They just didn't tell their neighbors that they were taking a long holiday. Sending somebody in to care for their property could really mess things up. These are the kinds of issues that we are discussing. We pick it up near the bottom of 38b. In the case of one who descends to abandoned property, the court removes it from the possession of the one managing it. And what is abandoned property? These are the cases that is abandoned property. Cases where one's father or brother or one of those relatives who would bequeath to him an inheritance went to a country overseas, and those in his locale did not hear that the relative died. It's just that somebody went away and hasn't come back. No one knows where he is. He went away, he hasn't come back. A year goes by, 2 years go by, 3 years go by. So there's somebody who is next in line to inherit that property. He's watching that property go to waste. I mean, imagine that the CEO of a company just goes away and lets the company fall apart. Who is the next in line to inherit that company? He doesn't want to watch it fall apart. He'd rather step in and start doing the job of running the company to save the company, right? But has the CEO actually gone away or not? So when we talk about abandoned property, this is somebody who just disappeared and we don't know what's become of him. And so an heir wants to step in and save the company. And here what we're learning is that according to the majority, the court says, you can't do that. That's not your property. We don't know that that person is dead. We don't know that that person is not coming back. Maybe you'll inherit the property. Maybe you won't. Maybe he'll change his will. Maybe he'll give it to somebody else. You can't just step in because you think he's been gone too long. So we remove it from the possession of this person who stepped in. And Rabbi Shimon ben Gamliel said, I heard that the legal status of this so-called abandoned property is like that of the property of captives. Now there we know the person was taken captive. We know what happened to him. We don't know when he's coming back, if he's still alive, but we know that he went away against his will. Abandoned is somebody who went away of their own volition. But Rabbi Shimon ben Gamliel says, I heard that the legal status of abandoned property is like the property of captives, and it is not confiscated from the possession of one managing it. Now, the dispute between the first Tana and Rabbi Shimon ben Gamliel parallels the dispute that we were discussing yesterday between Rav and Shmuel. So with regard to one who descends to forsaken property, the court also removes it from his possession. What is forsaken property? These are cases where one's father or brother or one of those relatives who bequeaths him an inheritance was here, and the relative does not know where they went. And everyone agrees that in these instances, the court does not authorize a relative to descend to the property. Again, we don't just let somebody step in. So in the first case, we know they went away, they just haven't come back. This forsaken property, we don't know what happened to them. Right? The law of forsaken property came out like this. This is the halacha. If one traveled of his own volition and his destination is unknown, the court does not authorize a relative to manage his property. And furthermore, if a relative steps in, they're using the verb descend, but they mean step in, descends to manage the traveler's property, the court evicts him from there. And the property remains as it was, as it is considered to be deliberately lost by its owner, a situation that the court does not address. The court doesn't step in for that. The court might step in for somebody taken captive. They might step in for somebody, where it's abandoned, where he might have been taken captive. We don't know. Forsaken means they just left of their own volition. Now, the Gemara asks, what is different about one property that is called abandoned And what is different about the other property that is called forsaken, right? These concepts seem very similar to each other. Now we're actually on 39a. The Gemara explains, abandoned property, netushim. This is referring to property that the owners vacated perforce. When it is written, but the 7th year you shall let it rest and lie fallow, Exodus 23:11, talking about the Shemitah year, that is expropriation by edict of the king of the universe, right? So in other words, somebody was forced to abandon the property. Shemitah year, people have to abandon it. Why are they talking about Shemitah, where God tells people not to farm their land? Just as an example of where an authority imposed that somebody be taken off their land. So abandon means not by their choice. Forsaken property, retushim, this is referring to property that the owners vacated of their own volition. As it is written, a mother was forsaken, Rutasha, with her sons, Hosea 10:14, indicating that the mother was left with the sons as all the men left. Right? So the basic difference, abandon was against the will of the owners. They were taken away. They left the property against their will. Forsaken, they left of their own will. Either way, the property is left alone, but abandoned was against the owner's will. Forsaken, it seems that the owner did it by his choice. Okay, so a sage taught with regard to the Baraisa, discussing the case of one who descends to the property of another. And for all of them, the court appraises their work as one would appraise the work of a sharecropper. In other words, when it is permitted for this relative to step in and manage the land, it's not that we give him the land, it's that he's able to step in and manage the land and get paid for his effort. And how is he paid? He's paid like a sharecropper would be paid. And the Gemara asks, well, when you say for all of them, to which property in the Baraisa is this ruling stated? If we say it is stated with regard to captive's property, well, now that the Tana stated that he is diligent and he profits, as he may take as much produce as he wishes, he can work the land if it steps in to handle while it's captive, while the owner is being held captive. Is it necessary to say that he can take a share of what he did to enhance the field? We already said that. So rather say that it is stated with regard to forsaken property. But didn't we just teach that the court removes one who steps in to manage forsaken property? So how could we say this is how he's going to get paid? The court is supposed to remove such a person. Rather say that it is stated with regard to abandoned property. And the Gemara asks, well, in accordance with whose opinion? If we say it is in accordance with the opinion of the rabbis, don't they say the court removes such a person from possession of that absentee owner's property? And if it is in accordance with the opinion of Rabban Shimon ben Gamliel, doesn't he say, I heard that the legal status of abandoned property is like that of captive's property, and the rights of one who labored in the field are superior to those of a sharecropper. So when you say we appraise his work in managing the field like a sharecropper, who are we talking about? And the Gemara answers, according to the opinion of Rabban Shimon ben Gamliel, the legal status of that property is in some ways like that of captive's property, but in other ways not like that of captive's property. It is like that of captive's property in that the court does not remove it from his possession. But it is not like that of captive's property, as there in the case of property belonging to someone taken captive, the one working his field is diligent, and he profits from the produce that he takes, while here one appraises their work as one would appraise the work of a sharecropper. So the Gemara asks, and what is different in this case from that which we learned in the Mishna on page 79b of this tractate? That in the case of one who outlays expenditures to enhance his wife's usufruct property, so we've talked about this a bunch of times, when a wife brings property into a marriage, should they divorce, she will take that property with her when she leaves. But as long as they're married, even though she technically owns the land, the husband has the right to work the land, and any produce, right, that he brings out of that land with his work is his, right? I mean, it's his on behalf of the household. Obviously, he also has an obligation to sustain his wife. But while they're married, this usufruct property, it means that the husband can use it and benefit from it. He can work it and reap all the produce from it. But once the marriage ends, she takes it with her. Now, what if he improves that property? He doesn't just farm it and sell the produce. He actually invests in it. Then what? That's what we're talking about. one who outlays expenditures to enhance his wife's usufruct property, which belongs to his wife, but whose profits are his for the duration of their marriage, and if the marriage ends in divorce or his death, and she reclaims the property, whether he spent much to enhance the property and consumed little, and did not derive benefit commensurate with his investment, or whether he spent little and consumed much, the principle is, what he spent, and what he consumed, he consumed. His labor is not appraised like that of a sharecropper. In other words, he invested in the land so that it would be more productive, so that he would get more produce out of it. But when, they end up divorcing and she takes her property with her, she doesn't have to reimburse him for any money he invested in enhancements of the land, because he did that to benefit himself. So what he spent, he spent. And then what he consumed, in other words, what produce he took from the land, he got to keep that while they were married. Once she leaves, she just takes her land with her. She doesn't have to reimburse him for anything. Now the Gemara answers, so this case is comparable only to that which we learned in a statement that Rabbi Yaakov said, that Rav Chisda said, the legal status of one who outlays expenditures to enhance the usufruct property of his minor wife, whose father died and whose brother and mother married her off, is like that of one who outlays expenditures to enhance the property of another, as this is a marriage by rabbinic law, and she can void the marriage by performing refusal. Right? So this is a girl who was still a minor. Her father died. Her family was starving. So they married her off, to some guy who was willing to marry her. This is not like child rape, right? He's going to marry her, but they're not going to consummate that marriage until she's an adult. And when she becomes an adult, she can say no and refuse that marriage. Because she has the right to do that when she becomes an adult. So during this period where a husband has the rights to this usufruct property that she brings into the marriage, it's going to be treated differently than usufruct property within a regular marriage, right? This is a special status marriage. And here, if he enhances it, it's going to be appraised like that of a sharecropper, where if a sharecropper enhances the land, he's going to be reimbursed for that when the owner comes and takes the land back from the sharecropper. So apparently, since he does not rely on the fact that her property will remain his, right, because he doesn't know that the property will remain his, because she could, the girl, when she becomes an adult, could refuse him and just leave and go back to her family. So he's not going to invest in her land, and we want to encourage him to make investments if that's going to save the land from being spoiled. And so how did they encourage him? By guaranteeing that he would be reimbursed for those kinds of expenditures. So apparently, since he does not rely on the fact that his property will remain his, the sages instituted on his behalf that he be reimbursed for his expenditures so that he will not devalue the property. And hereto the sages instituted on behalf of the one who labored in the field that he be reimbursed for his labor so that he will not devalue the property. Okay. The Gemara asks, with regard to the phrase written in the Baraisa, and for all of them, the court appraises their work as one would appraise the work of a sharecropper. So what additional case does it serve to include, as apparently it applies only to property of those who abandoned it, in accordance with the opinion of Rabban Shimon ben Gamliel? So the Gemara answers, it comes to include that which Rav Nachman says, that Shmuel says, for a captive who is taken captive, the court authorizes a relative to descend and manage his property. If he left of his own volition, meaning forsaken property, right? The court does not authorize a relative to descend and manage his property. And Rav Nachman says his own statement, the legal status of one who flees is like that of a captive. I imagine somebody's afraid of being taken captive, so he flees. Now, that was not his choice, right? He was afraid of being captured by the enemy or by his enemy, and so he fled his land. He wasn't taken captive, but it's not like he left of his own volition. And that's why we're going to compare one who flees to one who is taken captive. Right, Rav Nachman says the legal status of one who flees is like that of a captive. And the Gemara asks, one who flees for what reason? If we say that he flees due to a tax that he attempts to evade, that is the case of one who left of his own volition. Like whatever his strong reason is, it has to be a reasonable reason in the eyes of society, right? So if he's fleeing to avoid paying taxes. No, he's not fleeing like a captive. He's fleeing more like a criminal. Rather, the reference is to one who flees due to an allegation that he committed murder, and he flees to avoid execution. Now, we don't know if he committed murder or not. I think that what we're saying is it certainly hasn't been proven that he's a murderer. He is saying he's not a murderer, but he's afraid that they're going to bring false witnesses against him, and that's why he flees, so that he won't be executed. Now, he might be a murderer, and he might not, but he fled, So this is going to be treated like one who was taken captive. His legal status is that of a captive because he's running for his life. Now, if he's guilty, it's hard to have sympathy for him. If he's innocent, you can certainly have sympathy for him. Rav Yehuda says that Shmuel says, in the case of a captive who was taken captive, and he left in his field standing grain ready to be reaped, or grapes ready to be harvested, or dates ready to be cut, or olives ready to be picked. And the owner of the produce will incur significant loss if they are not harvested. Then the court descends to his property and appoints a steward to manage his property. And he reaps and harvests and cuts and picks. And thereafter the court authorizes a relative to descend and manage his property. And the Gemara asks, if that is an option, let the court always appoint a steward to manage the captive's field. And the Gemara answers, we do not appoint a steward for the bearded. We do not appoint a steward for the bearded. What, do they have prejudice against people who have beards? No, bearded means an adult, right? An adult. A steward is appointed only for orphans. So Rav Huna says, the court does not authorize a minor, even if he is an heir, right? He stands to inherit the property, but he's still a minor. So we don't authorize a minor to descend to the property of a captive. I mean, that makes sense. Maybe he's the son of the adult man who was taken captive, and he knows the land best. But if he's an 11-year-old boy, he does not have the legal right to enter into contracts to buy and sell property, etc. So we can't authorize a child to become the steward of this missing captive's property. And the court does not authorize a relative who is an heir to descend to the property of a minor that has no one to tend it. And the court does not authorize a relative, due to a relative, to descend to the property of a minor, right? The people that have, biased interests are going to be problematic. So the Gemara elaborates, the court does not authorize a minor to descend to the property of a captive, lest he devalue the property. And the court does not authorize a relative, due to a relative, to descend to the property of a minor. And the Gemara explains, this is a case where the minor has a paternal half-brother, and that brother has a maternal half-brother. And the concern is that the latter, who is not at all related to the minor who owns the field, will claim that he inherited the field from his brother. And the court does not authorize a relative to descend to the property of a minor. And the concern is that since the minor does not protest at the appropriate time and assert that the property does not belong to his relative, that relative will come to assume presumptive ownership of the field. Presumptive ownership is like squatter's rights, right? If the field seemed to be abandoned and somebody moved in and was farming it for 3 years, at that point, the people in the area are just going to assume this guy is the owner. I mean, he's been there for 3 years. Nobody stopped him. He must be the owner. And at that point, he's going to keep that field until somebody else can bring evidence that it's not his. Presumptive ownership, it's not dispositive. It doesn't mean he owns it, but it means that to get him off the land, you're going to have to prove that he's not the owner, right? That is very problematic. So Rava said, learn from the statement of Rav Huna that one cannot assume presumptive ownership of the property of a minor. Even if one took possession of and used the property of a minor for 3 years, this does not indicate that he has presumptive ownership of the property, because when he started, he took over property of a minor. So he can never assume presumptive ownership because the court protects minors, protects orphans. Rav Huna restricted the descent specifically of relatives to the property of a minor, indicating that those are not concerns when it is a non-relative who descends to manage the field. Apparently, the reason that there is no concern is that one cannot assume presumptive ownership of the property of a minor. And even if one continues to occupy the field that after the minor reached majority, he does not assume presumptive ownership because he started when the field was owned by that minor, as perhaps the minor was unaware that he is the field's owner. Perhaps the minor was just a kid. He didn't know what was going on with people taking legal action against a field that belonged to his father, and then his father was taken captive, or his father went missing, or his father fled, right? But the kid didn't know what was going on, and so we got to protect the rights of the minor. We're on 39b. The Gemara comments, and we said only in the case of paternal brothers that the court does not authorize a relative to descend and manage the property of a minor because they are potential heirs, right? They're sons of the same father. But in the case of maternal brothers, we have no problem with it, as they are not potential heirs. They wouldn't inherit from that same father. And in the case of paternal brothers, we said that the court does not authorize a relative only with regard to land. But in the case of houses, we have no problem with it, as there are neighbors who can testify that the house does not belong to those brothers. And with regard to land also, we said that it is only in a case where the minor's father did not draft a document of division of the property that the court does not authorize a relative. But in a case where the minor's father drafted a document of division, it generates publicity, and everyone knows which portion belongs to each of the brothers. And the Gemara concludes, but this is not so. There is no difference whether they are paternal brothers, and no difference whether they're maternal brothers, no different if it is land, and no different if it is houses, no different whether he drafted a document of division, and no different whether he did not draft a document of division. In all these cases, we do not authorize a relative to descend and manage the property of a minor to avoid that relative being regarded as the owner of the property. We want somebody who is clearly stepping in as a steward with no ties of his own, no familial ties of his own to that land. So everyone knows that he's only there to care for the rights and the land of the minor. And that when the minor becomes an adult, in case the actual owner doesn't come back, then the land will go to the minor. We don't involve relatives as stewards. New subject. The Gemara relates, there was a certain old woman who had 3 daughters. She and one daughter were taken captive. Of the other 2 daughters, one died and left behind a minor son. Abaye said, all right, so we got it, one woman, 3 daughters. The woman, the old woman, and one of the daughters is captive. That leaves 2 daughters not taken captive. Of the 2 daughters that were not taken captive, one died and left a son as her heir. And the 3rd daughter is alive and not captive, right? She's present. Okay, so what do? Abaye said, what should we do in this case with the property of the old woman? If one suggests, let us establish the property in the possession of the surviving daughter, the surviving sister, right? The one who is not captive and who is still alive. Well, this is problematic. There is concern that perhaps the old woman died in captivity, and if the old woman died, then the minor, right, whose mother was, his grandmother's the old woman, his mother died, and so if the old woman died, her property would go to her daughters, and the property of that one daughter would go, since she died, would go to this minor son. So this is a case where a minor stands to inherit, and we don't allow relatives to become stewards of a minor's property, as we just learned. Right, so there is a concern that perhaps the old woman died in captivity, and if the old woman died, the minor's son inherits 1/3 of her property, and the court does not authorize a relative to descend and manage the property of a minor. If one suggests, let us establish the property in the possession of the minor, well, that is also problematic. There is concern that perhaps the old woman did not die, and the court does not authorize a minor to descend and manage the property of a captive. So Abaye said, consequently, half of the property is given to the surviving sister. If the captives died, she is the inheritor of half the property, right? There's only 2 daughters remaining. So she would get half the property in any case. If the captives are dead, she is inheritor of half the property. If the captives are alive, then this is a case where the court authorizes a relative to descend and manage the property of a captive. For a minor, we don't do this, but for a captive, we might. And for the other half of the property, we establish a steward on behalf of the minor, as it is conceivable that he inherited the property. So Rava said, once we appoint a steward for half of the property, we appoint a steward for the other half as well, and it remains under his stewardship until the state of the captives becomes known. And that's a practical way to deal with this situation. Now, ultimately, in this incident, they heard that the old woman died, and they did not hear the fate of the captive daughter. So Abaye said, we give 1/3 of the property to the surviving daughter, and we give 1/3 of the property to the minor, as he inherits it from his grandmother by virtue of his deceased mother. And of the other 1/3 of the property which belongs to the captive sister, whose fate is unknown, we give 1/6 to the surviving sister. And for the other 1/6, we appoint a steward on behalf of the minor, as perhaps the sister died and the property is his. And Rava said, once we appoint a steward for 1/6 of the property, we also appoint a steward for the other 1/6 until the fate of the captive sister is known. And that's how they dealt with it. New subject. The Gemara relates. This is a very colorful incident. The Gemara relates. Mari bar Isaac, who was a wealthy and powerful man, had a brother whom he did not previously know, come to him from Bechazai, which was distant from central Babylonia. Okay, so we have this wealthy, powerful man, and as we're going to learn, prone to violence, named Mari bar Itzak. Let's call him Mari bar, spelled I-S-A-K. I'm going to go with Mari bar Itzak. And he knew, this I know from the notes, he knew that he had a brother, but he had never met the brother, right? He knows he has a brother, but he's never met that brother. And now this guy shows up coming from Bechazai, where Mari bar Itzak has heard that he has a brother, and so this guy shows up and he says, I'm your long-lost brother, right? I'm your brother from Bechazai. I'm here. And why is he showing up? He says to Mari bar Itzak, divide the property that you inherited from our father and give half to me, as I am your brother. So Mari said to him, I do not know who you are. The case came before Rav Chisda. He said to the brother, Mari bar Itzak spoke well to you, as it is stated, and Joseph knew his brothers, and they knew him not. Right? So parallel case. That Joseph recognized his brothers, but his brothers didn't recognize him. In other words, it can happen that people actually are brothers, but they don't recognize each other, right? So you're going to need more evidence, and so it's not that Mar bar Isaac is lying. He hasn't met you. Maybe he met you when you were little kids, but he certainly doesn't recognize you now. Why should he believe that you are his brother? This teaches that Joseph left Eretz Yisrael without the trace of a beard, and he came with the trace of a beard. And this proves that it is possible for brothers not to recognize each other. So Mari bar Itzak may be telling the truth when he claims that he does not recognize you. Rav Chisda said to the brother, okay, go bring witnesses that you are Mari bar Itzak's brother. The brother said to him, I have witnesses, but my witnesses are afraid of Mari bar Itzak, because he is a violent man. This is not such a law and order type of region, you know, and so somebody who is powerful enough and prone to violence is a very scary individual. And so this brother who's coming to challenge Mari bar Itzak and try to get half the property that inherited from their father, since they're brothers, you know, what witnesses are going to step up against Mari bar Itzak when they're afraid that Mari bar Itzak might hurt them? And apparently, you know, it was known that this Mari bar Itzak had such a reputation. And because of that, Rav Chisda said to Mari bar Itzak, you go bring witnesses that this man is not your brother. Right? Rav Chisda shifted the burden of proof because of Mari bar Itzak's reputation for violence. Mari bar Itzak said to Rav Chisda, is this the law? Isn't there a principle in these cases that the burden of proof rests upon the claimant? This guy shows up out of nowhere. He wants to get half of the property that I inherited from my father, and you're telling me that I have to prove he's not my brother? He has to prove that he is my brother. That's the way the law works, isn't it? Rav Chisda said to him, this is the way that I judge you and all of your fellow violent people. Mari Bar Yitzchak said to him, ultimately, if that is your concern, witnesses will come and they will not testify in his favor. They will lie and testify in my favor. I mean, if you're right that I'm such a violent guy, then why are you going to accept my witnesses? Why are you going to accept any witnesses? How can you do anything with a court proceeding if everyone is so terrified of me? Rav Chisda said to him, no, I disagree with you, because people will not perform two wrongs. They will not, A, refrain from telling the truth, and B, testify falsely. Maybe some people will be scared to come forward, but if we actually bring the witnesses forward, they will tell the truth in my court. Rav Chisda was confident of that. Ultimately, witnesses came, and they testified that the person from Bei Chozai was the brother of Mari Bar Yitzchak. Now at that point, the brother said to Mari Bar Yitzchak, divide the land and give me half the orchards and the gardens that you planted since the death of our father as well. Now, that's a different story, right? So Mari Bar Yitzchak has been in possession of this land that he inherited from their father for quite some time. And he's been working it and improving it. He invested in it. He built up that land. So the half that this new brother, Johnny-come-lately, would be taking, he'd also be benefiting from all the work and investment that Mari Bar Yitzchak put into that land since he inherited it. Rav Chisda said to Mari Bar Yitzchak, yeah, your brother spoke well to you. As we learned in a Mishna, tractate Bava 143b, that if one died and left adult and minor sons, meaning Mari Bar Yitzchak is the adult son, and this Johnny-come-lately was a minor son at that time, and the adult sons enhanced the property, well, they enhance the property, and the profit goes to the middle, i.e. it is divided between the adult sons and the minor sons. Okay, you built it up, you invested in it, and you did that for the benefit of yourself and your brother. Now, we're on page 40a, and I'm almost done. We're going to finish the discussion of this Mishnah number 4, and then I'll take some questions. Let me make sure that this document is working in my new setup. I think so. Okay. And likewise, Rabbah says they enhance the property and the profit goes to the middle. And Abaye said to him, are these matters comparable? There, in the case that the adult and minor brothers were together, the adults are aware that the minors exist and forego payment for their effort on behalf of their younger brothers. Here, in the case of Mari Bar Yitzchak, was the older brother aware of the existence of the younger brother so that he could forego payment for his labor? The matter continued to develop and came before Rabbi Ami. And he said to those who reported Rav Chisda's ruling, the sages stated a more far-reaching law than that. In the case of relatives who tend to the property of a captive, the court appraises their work as one would appraise the work of a sharecropper. Although the property they tended did not belong to them at all, they receive wages for their labor. Why then is the ruling now in the case of Mari Bar Yitzchak that payment for labor on property that is his we do not give him? Mari Bar Yitzchak should be reimbursed for his expenditures. And they returned and related this matter before Rav Chisda. And Rav Chisda said to them, how can you compare these matters? There, in the case of the captive's property, it was with the authorization from the court that a relative descended to tend the property. Here it was without authorization of the court that Mari Bar Yitzchak descended to tend the property of his brother. Right? He inherited from his father. He didn't realize that he only inherited half of it and the other half belonged to this brother. So there was no authorization for the court about that. And furthermore, Mari Bar Yitzchak's brother was a minor when Mari inherited the property, and the court does not authorize a relative to descend and manage the property of a minor. They returned and related this response before Rabbi Ami, and Rabbi Ami said to them, they did not complete conveying all the details of the case before me, and I was unaware that Mari's brother was a minor. Rav Chisda is correct. And that concludes our discussion of Mishnah number 4. And we'll pick it up with Mishnah number 5 on page 40 tomorrow at the same time. And hopefully, well, the system seems to be working. So I think we're in good shape. Maybe I can even get the intro music playing as well tomorrow. I think Nina was called away, or maybe there aren't questions. But I see Joseph said, I was literally just reading the story of Joseph and his brothers. And I think we're having discussion with each other, but not really questions. Yehuda says, Sal, the sound is superb. In fact, it's better than when you were on the West Coast. Maybe because you're closer to South Carolina. It's better, huh? That's interesting. I mean, I'm just using the onboard mic of the camera. If you're telling me it's better, okay, maybe I won't use that big microphone. Maybe the problem is the big microphone that I use at home, I don't have it close enough to me. This is a different kind of microphone that isn't intended to be so close. And maybe that's why it's working better. That's a good note. Thank you for that. Okay, so looks like no questions. Wonderful. Okay. So that's what I've got for us today. And with God's help, we'll be together again tomorrow for page 40, same time and place. Have a good night.